first, let me say that this is not about me. It is about you. If anything I say can help and inspire you on your own journey, that I think is the objective of this interview well achieved. So my name is Francis Goh. I graduated from the National University of Singapore in 1990. In 1991, I was called to the Singapore Bar, and I started my practice as a litigator. My specialization now focuses on international arbitration and mediation. Between the two, I am preferring mediation, and I'll tell you more about that later. And I feel that to be a complete lawyer, you have to master a range of skill sets.
So what are the specific skill sets that you feel that you need to master to become a all-rounder lawyer, in your opinion?
I'm focusing on the area of dispute resolution. Many people think that as a dispute lawyer, you only be good in litigation. Nowadays, it is fashionable for the same dispute lawyers to say that they are good in arbitration. And then when we introduce mediation into the overall conversation nowadays, many of them go like, what's that? That's one reaction. Then there are others that say, oh, mediation, no big deal. You know, it's very light on procedure and laws. We can easily do that. Many people don't fully understand the skill sets that are involved in litigation, arbitration, and mediation, and they do that to their own peril.
With that being said, could you please show us a time frame of your career path as well?
My advice to the lawyers out there is this cannot be rushed. I was an eager beaver young lawyer many years ago. I was like, let's get on with it. I couldn't wait to become great. But I realized that it is a journey. Cut my teeth in litigation. 1995, Singapore started to go into arbitration, and I was on the team that argued the first arbitration case ever in the Singapore International Arbitration Center. That opened my eyes to the possibilities of this new creature called international arbitration. Now I am what they call certified mediator, and they've got this sexy new title called mediation advocate. So not just are you qualified as a mediator, but very often you are the counsel in a mediation case. I became a fellow of the Singapore Institute of Arbitrators. Got headhunted to join my firm called Harry Elias Partnership. It's a local law firm. Been there for 15 years, and junior lawyers out there, aspiring lawyers, it is a journey that you are undertaking. It's not a marathon, but it is going to be a journey that you build one experience onto another until you finally feel that you have attained to a certain level, and then it's time to help others.
So after hearing your career so far, I'm sure you have many interesting stories from many of your cases. Can we hear what has been the most challenging case that you have been a part of till date? And has that changed your perspective in a certain way?
Wow, challenging case. There are too many to choose from. I'll choose this one. It's an international arbitration, involved parties from China, Vietnam, and Singapore. Subject matter was a distributorship agreement, and the cross-border element involved work in these other jurisdictions. And the parties had entered into a contract, a distributorship agreement, and then subsequently we had a dispute. No surprise there. It seems like people cannot live in peace. I'm acting for the respondent. He had sold out his shares in the distributorship agreement, and the other party was alleging breach of sale and purchase, breach of warranty, all of which my client was saying he doesn't know how to run his business, and he's blaming his business failures on me. And so we had to come up with a strategy. Obviously, the strategy was, let's defend you in this arbitration. And I explained to him, if you do not put up a credible defense, the other guy is just going to walk all over you and get judgments in default. So he agreed, and that got the other party on alert. And then I encouraged my client, let's urge the other party to come for mediation. And so we adopted a strategy where we wrote to the arbitrator and said that this is probably a case which makes sense to go to mediate, because even if we cannot settle, at least the issues will be more defined by the time that it comes for arbitration. The other party wanted to embarrass the client, and I pointed out to the other party's lawyer and said, you know what, if you had wanted to embarrass my client, should have sued me in court. But now in arbitration, which your client agreed to, you're stuck with confidentiality, and I'm going to make sure that I fight and make your client pay. So the process was a bit drawn out because there was resistance from the claimant, and it took us about close to a year from the start of arbitration to get to the mediation, and we managed to settle. My client was super happy, and he felt that settling before the Chinese New Year was like getting a hong bao, a red packet. My partners, I had to explain to them why I had not got billings for a 15-day arbitration, but instead had billings for an arbitration that settled in 1 day of mediation. But hey, I'm an equity partner, so my partners had to listen to me. You asked me what was challenging, and I would say the challenge is whether you can bring together a strategy to meet your client's best interests, even when it seems that you are not meeting your own billing targets, because that's a lawyer's interest. I have had 1 year of keeping a client happy and getting an outcome, and then I've had 2 other years free to do other cases. I find that kind of perspective of what makes for good lawyering is something that needs to be increasingly adopted by young lawyers today.
That is actually something that not many students hear from many lawyers. Most of the time we are hearing that, this is how it should be and this is how long it should take. But hearing how in real life, sometimes you have to adjust the framework for different cases and maybe take the client's best interest into heart and not just your firm's, is something I feel it should be more encouraged, like you said. So thank you so much for talking about that. Diving more into your experience with mooting and also the role arbitration plays in moot competitions. So did you ever compete in a moot competition before when you were a law student? If so, how did mooting prepare you for your legal career?
Gives me an opportunity to show off my trophy. I was a mooter in my freshman year at university in the National University of Singapore. I took part in the mooting competition. Obviously, back then, in the first year, freshman, I had no clue what I was getting myself into. Looking back, mooting was a great experience, and it sparked my love for advocacy. And as part of my journey, I've kept in touch with advocacy through practice and also in giving back in the Law Society. So I am now chairman of the Advocacy Committee in the Law Society of Singapore. The challenge I had in my mooting competition was that the law they gave us was undeveloped. So there was a possibility A and a possibility B. I had to argue for what the law should be. Now, when you're arguing law facts or even new law, the judges will intervene. So don't expect to have a prepared script. I remember during my moot, the finals, I had this prepared script of what the law is, what the law should be, what are the benefits. And 1 minute into my presentation, I was getting questioned by the judges. Just threw away my script mentally. And I just looked at the judges and I said, okay, let's talk to you. At the end of my speech, I thought I had really lost and made a mockery of myself because there were 3 judges in that competition. Every one of them were asking questions, and I was just responding, thinking about what I'd written and answering. And at the end, when I sat down, I was shell-shocked. I was numb. So you can imagine my surprise when they pronounced the winner, and I have this trophy now to prove to myself that it's not a dream. The judges in their remarks said something that stuck with me all these years. They said, you won because you engaged with the judges. That we judges are human, and we are concerned about what is the impact of the judgment or award that we're going to make. And you, the counsel, or any advocate for that matter, are our help. And so we ask questions because we need help. And when you are able to engage with the judge, who is your audience, and meet that audience needs, you have done a massive job in persuading that audience onto the justice and effectiveness of your case. Don't be afraid of judges. Don't be afraid to go off script. I mean, you spend weeks preparing your case. You know what your case is about. So talk to the judge about it.
So what you have mentioned also is a very common experience between a lot of our mooters as well, because they also get a bit shell-shocked when they are constantly being asked questions, and when they have to go off their script, they don't feel prepared for that. So I think your experience is a reminder as well for our students to, loosen up a little bit and just engage, as you were saying. Could you share one of the cases that you were a part of where creative advocacy strategies significantly impacted the arbitration outcome, and what key takeaways can mooters apply in moot competitions?
First point, forget about creative advocacy. It's something sexy. It's something everybody hopes to do. It's like the James Bond of the advocates. You see this one guy deliver this great question and the case is won. Not so in real life. It's important to use your imagination, but don't get so caught up in that one creative thing. All right? As a balance. Real life is about hard work. I know it's not glamorous. Hard work beats talent 99% of the time. So I give you one example. In a case that I did late in the day, the other party's witness was saying that he didn't know about some accounting. He couldn't know because nobody told him. This was something that happened 5 years ago. He can't remember. Plausible argument, right? So that was his line in response to my cross-examining. And I allowed him to say that because in my preparation, my client had given me an email from that period, which doesn't exist anymore because it had been scrubbed from the hard disk. They had changed laptops. There's doesn't exist anymore. But my client had the record of the email chain, which showed he had been informed, he had been aware, he just chose not to act on it. So I let him talk. 10 questions later, I referred him to this document. His face changed because he couldn't explain. And my next 10 questions then were, did you know about this document? Have you received it? And no matter what he said, the point was made that he was selective in his memory, he was probably lying, and that we had the documentary evidence that made out our case. So what's the story here? I wouldn't have found the document if I didn't ask my client, and that speaks for preparation. This was done months before the arbitration hearing. And into the style of questioning, nothing fancy. It's called closing the gates. I call it give the monkey enough rope to hang himself with. I just ask a whole series of questions, let him say whatever he says, and then bang, I give it to him at the end. So real advocacy is not glamorous. There's a lot of blood, sweat, sometimes tears when you don't get it right. But it's great when you see it all come together in a case because you say, yes, that is that point that made the day.
In your experience with multi-jurisdictional disputes, what are the most challenging aspects of managing different legal framework? And I ask this question because for mooters as well, they have to deal with different jurisdictional laws. So they often find it difficult to manage both legal frameworks from one country to another. So how can mooters tackle similar issues in moot competitions, if you have any advice for this?
Many mooting competitions case will involve international problems, cross-border issues. First, you have to bear in mind, is your mooting problem a civil law problem or a common law problem? Because the perspectives are very different. And still on this point, arbitrators, if you've done research on the people who are your judges, and in real life on the arbitrators, do they come from a common law background or a civil law background? Because the training and their approaches are very different. So your pitch as an arbitration advocate will be very different because how you persuade is going to be different. I'll move on to the next aspect, substantive law or procedural law. And so you need to familiarize yourself with how are things done. Give you an example. I'll say this cautiously and apologies to any listeners who are American out there. If you are up against arbitrators and advocates from the United States, they are very used to an adversarial system, extensive discovery, and all sorts of interlocutory interjections and applications. They thrive on that. Someone perhaps from a civil law jurisdiction may not understand that style of litigation. And so you need to find and adapt your styles. I'm not saying that the civil advocate must adapt to become litigious like the US counterpart. Could simply be sticking by your guns and say, Mr. Arbitrator, let's focus on the real issues at hand. How are these applications by my learned friend helping the real issues? From our research, the main issues are supported by 3 documents, and it centers on the interpretation of 4 material clauses. I do not see how extensive discovery by my learned friends are going to change the complexion of the argument. So if just by knowing your case and sticking to your guns, but understanding your tribunal and understanding what your opponent is like, you can adopt a strategy that can actually take the wind out of their sails. Because now the US counterpart is going to have to justify why he's doing what he's doing. All right? So you've basically used his procedure against him.
This next part of the interview, we'd love to talk more about law in Singapore. So how would you describe the current landscape of arbitration and mediation in Singapore, and what distinguishes it from other major arbitration hubs in the region?
Okay, thank you for the question. But I'm laughing because I gather that you are holding Singapore as a jurisdiction in such awe, and I don't think it's necessary. Okay, and let me tell you why in my answer. We'll talk about what's happening in the arbitration and mediation scene in Singapore. Then we'll unpack about Singapore's experience and what does that mean for the rest of the region. Arbitration has come a long way since 1995 when I did that first case. Now we are called the hub of Asia. In rankings, we're supposed to be on par with Hong Kong and maybe better or the same as London, and Dubai is coming up as well. And I think that all this thing about who's better is the wrong way to look at things. Rather, it's about options for the consumer. If I have a dispute, I have reputable centers in London, Hong Kong, Singapore, and Dubai that I can possibly bring my dispute to and get a fair resolution and outcome. That's the better approach. And I'm hoping that there will be more centers. I know THAC is doing a lot of work in Thailand, and I applaud it. I think it should do so because good ADR laws, and I say ADR now, not just arbitration or litigation, is because it gives investors confidence. Foreigners are coming into your country, they're investing in your projects, they're investing in your economy, in your people, and all they want to know is my investment secure? And if there's a problem, is there an internationally acceptable way to resolve the disputes? Because we understand it. There's no perfect jurisdiction. There's risk everywhere. But we just want to know that the risk is managed and something that we are aware of. So harmonization of international laws is critical to helping international parties greater manage their risk.
If you could go back and give your younger self some advice before law school or while going to a law school, what would it be and why? why?
If I had to choose, the comment I would give to my younger self would be have a group of friends who can enjoy the journey of your life together with you. All the things that I had said before about choices you can do by yourself. But at the individual level, and even in the international level, it's about community. It's more fun when you have somebody to share with. It's important that those people are like-minded, that share your values, and at the end of your own journey, whatever that may be, if you have had that group of people to enjoy the journey with you, I think you would be richer for it. Don't blame your friends. Okay, my friend made me do this. I listened to him or her and then made this mistake. No, but I'm talking rather about you being secure in yourself, having made those choices, and then you find, you are like-minded. You are like-minded. And we become friends and we journey together. Good luck to all of you, because the juggling I was telling you about is already a full-time job. You have to juggle all the aspects of your life, and I hope you have a good life.